Welcome, everyone. Thank you for coming and joining us. We're really excited to be here. So my name, like Rafa just said, is Zach Torres-Fowler. I am a senior associate with Pepper Hamilton. I guess we're soon to be called Troutman Pepper. I'm based in Philadelphia, New York, and I am a member of the firm's construction group. I specialize principally in international and U.S. domestic construction arbitration disputes. And like Rafa mentioned, I am a member of the Global Advisory Board for the ICDR-Y&I. So special thanks to Rafa and to Lewis and to the ICDR for helping to organize all of this. And as a warning to all the attendees, I have a 4-year-old downstairs, and I have a 6-month-old that is sleeping next door. And then on top of all of that, today my township decided to start road construction outside my window. And so there is literally a backhoe that is banging into the road and shaking my house while we're having this panel. So a very apt, I guess, event to happen here as we're talking about this construction. And so let me just kind of quickly go through the topic of what we're going to be discussing today. As you know, the title of this panel has been COVID-19 and how the outbreak has affected the construction sector in the Americas. But the real goal and what I really wanted to explore with this panel is how COVID-19 has affected the construction sector in various jurisdictions in very similar and very different ways. And I think as we go through the panel, we're very lucky to have this panel of a diverse group of individuals based in Canada, Peru, and the United States. And I wanted to kind of explore how they are viewing the world, how their construction sector and their unique jurisdictions has been impacted by COVID, and how that has affected project management, how that's affected dispute resolution, how that affects other issues that they're looking out for in the future. And so with that, let me go ahead and just introduce the panelists. So the first, I think in my upper left-hand corner is Sharon Vogel. Sharon is a named partner and co-chair of the Construction Infrastructure Group for Singleton Reynolds, based in Toronto, Canada. Sharon specializes in managing construction disputes in a variety of forums, including negotiation, mediation, arbitration, and litigation. And Sharon is also a senior fellow at the University of Melbourne, where she teaches international construction law. Next, I guess immediately below me is Jaime, Jaime Gray. Jaime is a founding partner of Navarro Soler Guerin, Paredes and Gray, Abogados in Lima, Peru. Jaime's practice focuses on construction and infrastructure law and dispute resolution in Latin America. And Jaime has represented owners, contractors, engineering firms as both an advocate and also operates as an arbitrator in domestic and international arbitration proceedings. And then last but not least is Steve Chippas, who is, I guess, both next to me and below me. Steve is a senior counsel with the international construction engineering firm of Bilfinger North America. And Steve coordinates much of Bilfinger's North America's legal operations on matters ranging from sort of corporate construction, contract review, to litigation and claims management. And Steve has a great deal of experience in the in-house counsel role for a variety of different engineering and construction firms, and has a wide variety of experience on projects around the world. And in addition to being an attorney, Steve is also a licensed professional engineer in Texas. So with that, thank you to all of you for joining us. We're very, very lucky to have you here. And so I guess, why don't we just go ahead and jump in. And what I guess I wanted to first cover was the general idea of what are the real differences and similarities you've all seen in your respective jurisdictions. So I guess let's start with Sharon. What are you kind of seeing in Canada? How do you see the world? And how has COVID-19 really affected the construction sector there?
There's been a huge effect, Zach, on the construction industry in Canada. Canada is federal by organization. So in the different provinces and territories, you are seeing different effects. But in each of these jurisdictions, emergency orders are in place, as in the US and as in Peru. The effect of those emergency orders is felt by the construction industry. The construction industry has remained open or closed to varying degrees in varying jurisdictions. And in relation to those projects that have been able to stay open, they need to comply with Ministry of Labor and also public health recommendations in order to stay open. And those recommendations essentially fall into three buckets. First, cleaning and disinfecting, which is fairly straightforward, keeping the sites clean and disinfected on a daily basis. Second, physical distancing. And third, absenteeism and sickness policies, including some sites are testing on the site before anyone goes on a site. So as a result of that, we're seeing claims. And those claims include claims made under force majeure provisions, if those provisions are in place in relation to specific contracts, as well as claims made in relation to changes in law. Because of these public health guidelines, Ministry of Labor guidelines, and emergency orders that are in place, the claims are being made in relation to those changes in law, which is the way they are being characterized by some. As well, we see various supply chain issues arising. Initially, it was equipment and materials from China. Now, we're seeing more problems with equipment and materials from Europe and other places. So in terms of trends across the country, those are the kinds of things we're seeing. And as I said at the outset, it's different depending on what jurisdiction you're in. In Ontario, the big infrastructure projects in relation to both transit and health have stayed open throughout, as opposed to Quebec, where the entire construction industry shut down for a period of time. Now, in Quebec, the construction industry is back up and running with these kinds of guidelines in place. And in Ontario, as of last week, the construction industry is up and running, the entirety of the construction industry back up and running. So that's what we're seeing in Canada. Could get a second wave, so further shutdowns could happen.
And then thanks, Sharon. And let me turn to Steve then. You know, I know you're based in Texas, which has a very different approach than, you know, what I've seen in Pennsylvania, New Jersey, and the Northeast, and New York. Why don't you kind of just, I know it's a wide swath of country, but why don't you kind of give us a sense of what's going on in the United States in the construction sector?
Sure, Zach. We're seeing things very similar to what Sharon mentioned here. There is definitely a variety of approaches across the country. As you mentioned here in Texas, construction industry was never shut down. It was subject to, obviously, some of the safety regulations that Sharon mentioned, social distancing, cleaning. We had a lot of our clients doing temperature checks on the way in. We've had clients actually mandating testing in some sites, but to that extent, we really haven't seen any significant impacts in Texas. Now, we go to some other parts of the country. I know, for example, Michigan had shut down construction entirely at the outset here. I think that's opened back up. And I think there's a lot of people recognizing now that if we do this properly in terms of safety measures, social distancing, to the effect you can apply it in the construction industry, because it's not always possible. A lot of the work that Bill Finger's doing right now is large-scale piping on petrochem projects. I can't always keep 6 foot distancing. If I have a welder and a fitter and a welder's helper, putting them all 6 feet apart doesn't really help anything. So there's some practical issues that need to be addressed there, in addition to appropriate PPE for the work you're doing. Masks and things like that are not always appropriate in those cases. So we're seeing people make adjustments, but we are seeing the government actually recognize that this is an opportunity. Just here, our office is in north of Houston, up in the Woodlands, and we had a road widening project that was supposed to take 6 months. I think they knocked it out in 17 days. Because there's nobody on the roads. And I think either this morning or yesterday, even Governor Cuomo in New York said, hey, let's take advantage of the relative wide open spaces. Let's get some of these infrastructure projects done. Let's get some of these other projects done that we can effectively move forward quicker, cheaper, and take advantage of it. So I think that there was an initial, obviously, I guess, kind of narrowing of the funnel. but we're definitely seeing that funnel open back up again with regard to projects and opportunities. And that includes even our private clients who had maybe started to push things out to the right, and maybe are bringing some of them back to the left again now in terms of schedule and future work.
Great, thanks, Steve. And then let me turn to Jaime then. What's been the experience kind of in Peru, and really, to the extent you can talk about it, more broadly in Latin America. And Jaime, I think you're on mute.
Sorry, I was muted. Okay, thank you, Zach. Construction projects in Latin America have been severely affected, as most of them have been halted as governments order lockdowns and curfew as early as March 16th. Maybe Brazil and Chile could be the exception, but in general, the rule is stay at home. And again, that's mandatory. However, a few countries decided to allow some projects to continue as they are important to mitigate the financial consequences of the lockdowns. For example, in my country, Peru, a number of construction projects related mainly to mining have been allowed to continue. Very recently, the number of types of projects allowed to proceed has been extended. The governmental decision to hold construction activity has had a big impact on the market in general. However, it has especially affected workers, and that's a terrible thing, Zach, honestly. In addition to that, I should say that the supply chain has also been affected. Just as an example, if factories cannot produce equipment and components and the borders are closed, that's important. The borders are closed. Both contractors and owners are prevented from providing basic elements necessary for their construction projects. Governments have approved a series of health protocols, very similar to what has been mentioned by Steve and Sharon. And yes, these protocols are enforcing the use of masks and social distancing, and the testing of body temperature for personnel, the introduction of certain sanitation measures such as washing hands frequently, etc., and enforcing the presence of doctors and nurses at each project site, etc. Furthermore, some private projects have been suspended while others have been completely terminated, as these new work conditions approved by governments were considered by some owners to be too costly. On the other hand, some governments have passed legislation allowing public owners to grant extensions of time and to pay the associated costs, both direct and indirect, related to the stoppage and the cost of implementing these measures. The good thing is that some governments, such as Peru again, are allowing changes in construction methods to improve the distancing between workers or productivity itself, as well as the use of building information modeling. The use of international construction model forms as a way to enhance the relationship between the parties and apply the best international practice have also been promoted. Finally, the government of the state of Sao Paulo in Brazil has created a specialized court to deal with issues arising from this pandemic. That's an interesting way to respond to legal emergencies during this period, I think, Zach.
Great, thanks, Jaime. And so, with all of that said, there's obviously a lot of similarities between what each of your jurisdictions has been experiencing, a lot of differences. And I guess I wanted to take that experience and really translate it into how, really in the current environment, how are, contractors and owners really trying to manage these risks and the disruption that's being felt by COVID-19. And I thought one of the most interesting sort of differences that I've seen between what the U.S. and Canada and Latin American countries like Peru are really experiencing is the degree to which the change in law issues have been maybe not severe, but more all-encompassing, I guess, that we've seen in Latin America. In the United States, it's been more of a patchwork response, whereas I think in countries like Peru and in Chile, we've seen maybe slightly more draconian measures that have been imposed. So Jaime, why don't you talk about how projects in your region of the world are really impacted by the specific change in law measures that governments have enacted?
Okay, Thank you, Zach, again. You know, as I'm sure you're aware, civil law has a number of mechanisms, okay, which in theory could help parties to manage these types of situations. As you or my fellow panelists mentioned, force majeure are one of them, but we have excessive onerousness of the contract obligation and provision. That's French, because French claim they invented it. Italians disagree, of course, just to mention a few. However, honestly, all these legal theories, these proud theories, have been have fallen short, as they were not designed to cope with catastrophes of this magnitude. Civil law professors are rethinking the entire civil law applicable to contracts to cope with these types of catastrophes. Consequently, we have seen that instead of arguing and making claims as always, it makes much more sense for the parties to openly, honestly negotiate in a spirit of collaboration and transparency. For example, some parties are now willing to share some risks and avoid the natural risk premiums that contractors would add to their lump sums, and in general to those risks that they cannot really measure. Measurement is a thing, it's an important thing. Consequently, reimbursement and cost plus types of contract are back in the market. That said, formal claims and subsequent arbitration have not been completely discarded at all, but are not frequent, at least during this first stage of the pandemic. In Chile, mediation has been successful in recent times. Regarding specifically to change in law, which we understand it as a clause recognizing the effect of the new regulation on the party having to comply with it, specifically, we have to say that it is a common clause in Latin America, but this does not mean that all construction contracts have one. Maybe because parties for centuries have relied upon civil law, and as we said, it has fallen short. If parties have the change in law clause, they should differentiate it from the force majeure clause. The change in law, as we said, adjusts the payment to the party, normally a contractor affected by the new regulation, while the force majeure clause is a defense against the consequences of non-performance of obligation, and on very rare occasions also mean money for the contractor. Finally, against what was previously standard practice, some parties have accepted the use of early warnings, and more contractors are agreeing to show their actual registers of productivity, etc., in order to try to share price risk.
So I see Steve nodding his head, and Jaime, kind of building off of what you were saying about cooperation and modifying some of the approaches that might normally be taken on construction projects. Steve, when you and I first spoke, kind of discussed this panel, you mentioned, that there's maybe some more willingness on the part of both contractors and owners to really work together to recognize that this is a unique scenario. Can you kind of discuss, in your experience, what Bilfinger has seen in terms of managing COVID-19 as opposed to claims building or claims management or posturing? You've seen it quite differently, it sounds like.
Absolutely. Well, and we've seen a little bit on both ends, but we have seen it, as Jaime mentioned, trending more towards the cooperation side of things. How do we get through this? How do we get these projects over the finish line in a reasonable fashion? We've had some of our clients come to us and say, hey, can you help us set up you guys have a really good HSE program. Can you help us set up screening at the front gates for everybody coming into our project, so that we know that we're not letting people in who might potentially have COVID and have the effects of that on the job site. We've had a client who actually suspended other contractors at the site so we could have more room to do what we were doing, which was a more critical path related type of work, so that we could achieve some of the social distancing and spacing. And this gets particularly complex on large job sites. If you think about it, most large job sites, there's a lunch tent, there's a limited restroom and break facilities, so social distancing is extremely difficult. in those cases, because you're talking about, rows of picnic tables or whatever it is, and people eating their lunches and maybe a lunch truck on the site or things like that. So the cooperation aspect there has been, I think, critical in getting some of these projects moved forward. And as Jaime correctly pointed out, force majeure is a shield. It's not a sword. And I think the correct application of that is as he mentioned, if it's a lump sum project and the contractor is seeing efficiency issues, share your PI with the owner. Here's what I budgeted. Here's what I expected. How can we make this work? You've seen my guys out there. You've seen what it takes to make this happen. Let's figure out a way to effectively run this and keep these projects moving forward. On the other hand, we've seen people try to use force majeure as a sword. And Zach, I think you and I talked about this a couple of weeks ago, and without giving away any, confidential information, we had a client who basically said, hey, the government has shut this project down, shut everything down. Everyone go home. We can't do the work. And we looked at the executive order and said, no, we don't think that's the case. And we actually had one of our construction superintendents, it's one of the smaller states in the US, and he actually somehow found the governor's cell phone number and called the governor's cell phone. The governor's administrative assistant answered, and he said, hi, I'm so-and-so. I work for so-and-so. I'm on the XYZ project. And the owner says, we need to shut down. And the lady says, we know that project. Let me talk to the governor. I'll get right back to you. Literally 10 minutes later, she calls back. She goes, I talked to the governor. He knows that project. And he says, you guys got to keep working. That's an important project for our state. You got to keep going. And a couple of days later, our client came back and said, well, we're going to terminate the contract for convenience then. So I think it's an opportunity for projects that were in trouble to use that as an excuse to go and get out of a contract maybe they didn't see to be beneficial for them anymore, to address other issues around that. But I think the vast majority of what we've seen is a cooperative attitude, a joint effort attitude in order to help push these projects forward and keep them going as best we can. And I think Jaime touched upon one of the key issues. Construction is a huge driver of the economy, not only in the US and Canada and in South America as well. The studies I've seen is that every construction job creates 6 other jobs around it. So whether that's supply, PPE, food, whatever it might be. So I think there's a recognition that these are critical times, and that cooperation was the best method to push these forward.
Well, and let me push you on that one, Steve, and I'll open this up to the rest of the panel, though. We all hear, in theory, cooperation is always the best approach. And at the end of the day, we are all trying to execute a single product, right? We're trying to deliver a project. But how hard is that actually? How hard is that really to deliver? Is cooperation, while in theory very good to pursue, how difficult is it to actually achieve? Your experience and Sharon's experience and then Jaime's experience.
Well, that's actually a great point, because let's face it, construction, whether it was intended to be that way or not, is now an adversarial pursuit for the most part, unfortunately, right? There's a certain us versus them attitude. And I think it's times like these where you can see a little bit of a shift there. It is difficult, right? Because let's face it, at the end of the day, we as the contractor want to keep working. But we have to be fairly compensated for what we do. Bill Finger is a for-profit company. One of the keys to that is that we make a profit. Otherwise, it's not worth us being in there. The old phrase I learned early in my career is that you can't lose a little on every job and make it up in volume. So you have to continue to make a profit. The owner, on the other hand, says, I want to pay X for this project, and I don't want to pay more than X. So there's got to be some meeting in the middle there, right? The owner can't be expected to pay 200% worth of the project, but conversely, the owner can't expect the contractor to absorb all the costs from this. Because I think, as both Jaime and Sharon pointed out, the contractors, I think, for the most part, have some pretty good legal approaches here. And I know we're going to talk about that a little bit later on. So in theory, it's great. In practice, it's actually been working fairly well. What will be interesting to see is what happens is as we kind of move beyond that, and particularly in some of the places here, like in Texas, where we are getting pretty much opened back up again. And we see that there's less of a pressure on these types of things if that spirit of cooperation continues or not. That'll be, for me, what'll be the interesting thing to see what happens here in the next couple of months.
Sharon, what's your take on all of that?
I would agree with what Steve said in terms of we're seeing people really trying to cooperate. Yes, often construction is an adversarial process, but in a time like this, it's a crisis. So people realize there's going to be a time to try to work together in the best interest of the project. Now is that time. So they're trying. And so Jaime mentioned early warnings, and Steve talked about open book sharing of how the project is going. So in Canada, we're seeing some of that too. And seeing in terms of general contract management strategies that people are trying to manage contracts in a fair way, and to ensure that payments aren't slowed down, for example, that progress payment applications are because people are facing cash flow issues. So owners are doing their best to manage those contracts. Where I've seen on projects, and I don't think there's a project that I'm involved in where I haven't seen a claim. Like there's claims on every project that I'm involved in. How big those claims are going to be, who knows? But there's a concern in terms of granting relief. We all agree that force majeure is a shield that largely gets you time, but not money. So contractors are looking for avenues to get additional money. And some of it is pretty straightforward. Additional money to do some cleaning and disinfecting, for example. Additional PPE, sanitation stations. That's fairly straightforward, but owners are concerned about the slippery slope of supply chain problems, loss of productivity. Steve told a terrific story about a Texas road widening project that's going really well. We have a whole series of transit projects ongoing in this province that are not doing so well, even though they have increased opportunities for lane closures, etc. That productivity is way down because of employee absenteeism, difficulties in completing certain types of work because of physical distancing requirements. And those are the kinds of claims that can get really large. So owners are very concerned about the slippery slope of, oh sure, paying for a little bit of cleaning and disinfecting, but opening themselves up to the monster claims associated with loss of productivity, delay, disruption, supply chain issues, all of those issues, which could be some pretty large claims.
And what about kind of notice management in general? I know you were discussing claims. Obviously,
Sure.
Most construction contracts require notice to be submitted within a particular period of time.
They do, and it's usually pretty quick.
Yeah. But how have contractors kind of on your end managed this process? In particular, given that it's quite difficult to pinpoint, when the event really occurred, right? Like COVID-19
Sure.
is, a pretty broad brush.
Yeah.
So how have you
For
managed?
sure. Yeah, and it's easier on some projects than others, and with the Quebec construction industry shutting down at the end of March, that's pretty easy date. You're shut down, you're suffering from effects. In Ontario, where there was a lot of uncertainty in the early days about what was an essential business or was not, so which projects could stay open or not. So contractors were looking for notifications from owners about whether they could stay open or not, whether they were an essential business. So there was a lot of uncertainty there about whether projects were open or closed. That got sorted out. And then the effects of COVID started to be felt in terms of loss of productivity, supply chain issues, absenteeism, etc. So the notice requirements are pretty strict in many of these contracts, 5 business days, sometimes less, to give the initial notice, which to give initial notice, and as I said earlier, the claims have flooded in. So there's been lots of initial notices, and contractors in my jurisdiction at least, have erred on the side of giving very detailed summaries on a week-by-week basis of the effects, but then providing the additional detail about the effect of those issues that have arisen on the timeline for the project, that has been much more difficult. So what we are seeing in some instances is that notice protocols have been entered into where owners appreciate the early warning of that initial notice of, tell us what you know now, let's work on mitigation strategies together in terms of dealing with physical distancing issues or whatever they might be, only one person in a hoist or whatever that might be. Let's work on mitigation strategies to try and solve the problem first. And then we as owner will agree that you don't need to provide that further analysis, that critical path analysis that shows exactly how long the project is going to be delayed, because in part, given the uncertainty about projects staying open and the extent to which they can progress the work, it's been really difficult for contractors to provide that kind of detail, even if it's contractually required. So we are seeing some notice protocols being entered into as a mechanism to deal with that.
And let me, I guess, stay with you, Sharon, just maybe shifting gears slightly from kind of the maybe project management, claims management side to more of the dispute resolution side. And you know, Jaime's mentioned it, Steve's mentioned it, you've mentioned it, but, you know, obviously force majeure is a big deal. That's going to be an issue that people are going to litigate. Change in law issues are going to be a big deal. Delay and disruption claims are going to be a big deal. Can you, why don't you kind of explain, you know, what you see as the kind of major legal issues that you see claims, or that the major legal issues that you see arising kind of in the future claims world that we're going to eventually see coming from COVID-19?
Sure. So we've talked about force majeure as a shield, which largely gets you time and not money. So contractors are looking for compensation and extensions of time. So where can they go in the contract? So you have to look at each contract as it exists. And yes, Jaime referred to, you know, standard form contracts in the international sphere, where we see, you know, detailed provisions on change orders, variations. How do you get into that realm of showing that there's been a change to the contract? So one way that I mentioned earlier is a change in law, that there's been a change in law that adversely affected the contractors because these new guidelines have been imposed, which can be characterized in some jurisdictions potentially as guidelines imposed by a statutory body, depending on the jurisdiction, because it could be Ministry of Labor. Sometimes they're not framed in mandatory terms. So the extent to which they actually are changes in law or not is going to be a matter that I think the courts are going to have to take a look at. As well, in some contracts, there are emergency provisions. So an owner might have a discretion to notify a contractor that there is an emergency and that it requires the contractor to take certain steps. And if it takes those steps, then those are additional steps that it wouldn't otherwise be required to complete under the contract, then the contractor can say, you are obligated to issue a change order or a variation in relation to those steps. Now, whether in a jurisdiction where the province has declared an emergency, an owner is obligated to exercise that discretion to declare an emergency, I think is going to be another issue that is going to be subject to some debate. And then another area where I think you're going to see some claims is insurance policies in relation to these projects. In addition to the notices that contractors are providing to owners, they're also providing notices which are required to be provided under the terms of the various policies that are in place. What coverage is available is going to be another issue. You have to look at each policy on its basis, because you look at, for example, a wrap-up liability or commercial general liability policy. Well, it requires bodily injury or property damage. Do you have bodily injury or property damage? And one of the issues that I've heard discussed is in relation to property damage is the lack of ability to access a project site. So the inability to use the property for its intended purpose. Can you characterize that as property damage? Which I thought that's a pretty innovative argument, but can you see an insurer just saying, oh, yes, I agree that that's property damage? I think that the insurers might say, I know you actually need some detrimental effect on the property itself.
Thanks, Sharon. And I guess the other kind of side of this is, once you establish entitlement, whether it's force majeure or delay and disruption or under your emergency provision language, how do we quantify it? And how difficult is it going to be to really quantify the impacts associated with COVID-19? Again, it is a broad, kind of all-encompassing emergency. Jaime, I guess from your perspective, what are what are sort of the legal issues you're going to see in terms of quantification of these damages, both in time and in terms of money, and how are, from your perspective, what are the best sort of practices in terms of managing that effort?
Thank you, Zach. However, if I may, I would like to share a couple of very short ideas on collaboration. Okay, an important issue. Sorry for this. The first idea is not mine; belongs to Yogi Berra, and it says that in theory there is no difference between theory and practice. In practice, there is. The second is that collaboration only works if both parties really are benefited from its use. So if we have that, we have collaboration. If not, I doubt it will be working. Okay, that said, let me return, and I promise that I will be answering your question. Okay, and I think that we all know the answer, and the answer is that it will be extremely difficult to assess the quantum of damages. There is no precise and reliable method for this, and consequently, the regular, quotation marks, regular expert assessment will have to be modified, challenged, etc. One simple method, okay, which is related to the legal issues, would be the simple comparison between the cost incurred before the pandemic versus the cost incurred after or during the pandemic, a sort of, again, quotation mark, measure mile of incurred cost. However, obvious methodological concerns and objections will arise, as this way of calculating the quantum does not consider the accuracy of the cost, or if some of the costs were caused by negligent acts or omission on the part of the contractor. And here, a legal thing comes. That's concurrent liability in the generation of the cost. Another important issue to analyze is the impact of the measures against COVID on the productivity of the projects. Here, the measured mile method could certainly help more, but as construction is not a linear activity, every expert could modify the methodology, and not all registers are complete or accurate again. Therefore, some objections are expected to arise. What is undisputed is that parties will have to identify which portion of the damage they suffer is attributable to their counterparty. If the change in law clause, again, the change in law clause, says that it is an owner's risk, of course, this necessitates transparency at its best. And that will require a significant cultural change, as cost, productivity, expenses, etc., should be actual, should be real, and be duly proven by ordered and contemporaneous records of contractors. And that's a challenge from a cultural point of view.
And I guess, does anyone on this panel think that you could readily quantify at least some of the impacts associated with COVID-19? Because and that's a very broad question, but you know, you do have owners, I'm sure, based on your experience, who are sitting there demanding you got to tell me what these costs are now so I can plan ahead. What is your response to that sort of scenario? I'll let any of you speak. You feel free to jump in.
Well, I'll jump in. I think that, Zach, to a certain extent, you can quantify some of this. As Sharon pointed out earlier, we're bringing in hand washing stations or more PPE or things like that. So that stuff's relatively easy to quantify. I think what Jaime was just hitting on, which is where it gets much more difficult, is in quantifying the efficiency impact of these types of delays, right? Because these delays are hitting different times in projects, right? If you're just getting started up in a project, your efficiencies are by nature lower than what you would expect them to be. If you're in the middle of the project and you're doing great, your efficiencies might be above what you had originally projected. So in terms of what are you actually entitled to, it's very difficult, right? This is, COVID's going to be very beneficial for two groups of people. One is attorneys who settle construction disputes, and the other is going to be for the experts that support them, right? The FTIs of the world, the roads groups, guys like that, who make their money coming in and doing, whether it's measured mile or windows or whatever type of approach it is that you want to have. So if an owner were to come to me today and say, hey, what is the quantification of this going to be? I think to a certain extent, I could give him some hard numbers. And then to a certain extent, I would have to give them my best estimates as to what it's going to be, because it's going to depend on a couple of things, right? One is, are the current restrictions going to change, right? Instead of 6 feet, are we going to go to 9 feet, or can we go to 3 feet? How many people can I have on the job site? There's going to be a lot of factors there that could change down the line. They're going to impact that. So I think you can provide a rough quantification of some of these things, right? If we know that we had, 50 people on the site, now I can only have 25. Well, right away, my productivity just dropped in half. And the productivity of that 25 is not going to be full as to what it is, because they're not going to be able to work as efficiently, because maybe I don't have tool runners. So now I've got to have a guy walk from where he is back to the tool shed to grab that tool he needs, rather than somebody who's going to go and get it for him while he continues productive work. So there's a lot of factors here. So I think, unfortunately, it's going to be very difficult to quantify. For myself, who operates principally as a transactional attorney, so trying to set my contracts up to be beneficial to me in these situations, there's a lot of things that are going to start getting put in contracts going forward, right? And some of that is going to be looking for compensation for force majeure events, because I think this is a very clear illustration that putting the risk of cost for force majeure event on a contractor is just grossly inequitable. There's no way contractors can really support those. My change in law provisions, same types of things. My delay provisions, and how those, what triggers a delay, and issues around concurrency and things like that. So I think this is going to be a very interesting time, not only how we settle these disputes, but how we change the landscape of those disputes in future projects.
So let me take that and segue into the next topic, Steve, because that was actually quite helpful. How do we resolve these disputes? The ICDR's caseload is a significant portion is construction disputes. And what I guess I want to ask you guys is, does COVID-19 change anything about the way we select arbitration or international arbitration, or any other sort of mechanism that's kind of unique to the construction world in terms of resolving disputes? How do you feel COVID-19 is going to affect the dispute resolution process? And I guess Sharon or Jaime, feel free to jump in.
Well, I think there's going to be an increase in claims, Zach, as we've already described. We're seeing that these are going to be some of difficult claims, and the contracts are difficult to interpret. The standard form, Canadian Construction Documents Committee contract that's in use widely in Canada, in relation to its force majeure clause, it doesn't refer to a pandemic or epidemic. So the applicability of these clauses is going to be up in the air, as well as knowing that contractors could look to other clauses in the contract that we've described, change in law, relief event, delay event, emergency, that those are difficult issues. So I think that they're well suited to resolution through arbitration, where you have a subject matter expert arbitrator, somebody like Jaime, who, and recognizing a lot of these will be virtual arbitrations potentially, and people will be more amenable to a virtual arbitration for the go forward. I think this will be an industry changing event in terms of our willingness to utilize remote dispute resolution techniques, such as remote mediations, to try to negotiate. If we're talking about Steve and Jaime's idea about collaborative resolution, well, you can try and resolve it through negotiations yourself or through mediation, and you can do that even remotely. And international arbitration for the more difficult issues, I think, will still be a go-to mechanism. Here in Ontario last October, we introduced adjudication, which is meant to be a swift and flexible dispute resolution mechanism. It's interim binding, and it's intended to take place within a 39 to 46 day period. So it's swift. So for some of the more contained types of disputes, you could use a mechanism like that. But for some of the really large and complex disputes involving delay analysis, where you need extensive expert evidence, that I think you need more of the procedural protections that are afforded through an arbitration process.
I share Sharon's views, and I think that we should expect an increase in the number of arbitration cases for the ICDR and other arbitration centers. That means, not only that the virtual hearings will be the rule, also parties will need emergency arbitration procedures, to expedite the cases. So that will be definitely, in my view, not the future, it's the present right now. And despite parties preferring to negotiate sensibly or use other ADR methods, such as dispute boards or mediation or adjudication, Sharon has said, I think that a considerable number of issues should be expected to be resolved only via arbitration, as this crisis is constantly developing and new issues are arising all the time. And in my experience, when agreements are revised many times and again, both a loss of trust and escalation of a conflict can be expected. And arbitration is a natural way to resolve these types of issues, both internationally and locally in Latin America.
And Steve, I see you're nodding your head often, but I guess maybe to play a little bit of devil's advocate on your part, how do you think the financial pressures on construction firms in particular will impact their decision making in terms of proceeding to arbitration?
I think short-term, Zach, that is going to be the controlling factor in a lot of this. Let's face it, construction is not a high-margin business. This is not pharmaceuticals. This is not iPhones. Construction survives on single-digit profit margins on a good day. So, to paraphrase, justice delayed is justice denied. Payment delayed is even worse from a contractor perspective. So I think if you're looking at a contractor who might be in a cash flow situation because of COVID, maybe some projects were delayed or pushed to the right, and he's not getting that cash flow. Maybe he's got a credit facility he's got to satisfy and he needs to make a payment. Whatever the scenario is, I think there's going to be a significant number, and maybe not the major contractors, but definitely when we get into the subs, the first, second, and lower tier subs, the cash flow pressures are going to be enormous. And I don't think they will have the stomach or the financial wherewithal to take it to a formal arbitration proceeding. I think you might see some mediations, but I think, unfortunately, I'm going to add a new term to our dispute resolution lexicon, and that's capitulation. where especially the smaller contractors are going to say, hey, I'd rather have $60,000 today than $100,000 18 months down the road, because at least with that 60, I can make some payroll, I can put gas in the trucks, I can chase another job or two, and maybe have some cash flow coming in there. So I definitely see that as being a overriding factor here. And I have to agree 100% with what Jaime and Sharon have said. I think this is really going to change the landscape for dispute resolution in the construction industry. And I will fully admit that I, before this, was much more of a litigation preference type of person for several reasons. But when you look at how overloaded the court systems are in general, and how they are absolutely floundering right now to provide basic services to the public, and how so many of these things are getting pushed so far to the right, I think you will see more, for lack of a better phrasing, private dispute resolution, whether it's arbitration, dispute boards, and things like that, simply because you can carry on pretty much as normal in these types of situations using Zoom or Skype or whatever it is, and you can move forward and get these things done. So I definitely see in my documents going forward, I think we're going to see a lot of people doing the same thing, moving potentially away from litigation to arbitration, simply to avoid a situation where you are in a legal limbo for months and months and months without recourse because the courts are shut down or inaccessible, where you could move forward and, as Jaime said, potentially in some form of expedited fashion to get a private adjudication completed.
And so I recognize it's 1:56. I wanted to keep it to an hour. To the attendees, to the extent you have questions, there is a Q&A button at the bottom of your screen. You should feel free to ask any questions to the panelists. And I guess it'll take you probably some time if you want to type anything. But in the short interim, while you guys are thinking of questions, Sharon, Steve, Jaime, are there things just kind of going forward that you're looking out for, that you expect to arise associated with COVID-19 that people haven't really discussed or spoken about before?
I think, Zach, I think watching policy changes and legislative changes will be a really interesting thing to watch out for. We're seeing legislation to relieve parties from their obligations in construction contracts in Singapore, advance payments under construction contracts in the UK and Singapore, government announcement that COVID constitutes a force majeure for public contracts in France, long stop deadlines for the construction of wind and solar projects in Germany, relaxation of building code requirements to allow expedited healthcare construction, for example, in Germany. So really some fascinating policy and legislative developments that I think will be interesting to keep an eye on. We're in early stages, very much a patchwork quilt, but I think that that's going to be something interesting.
Yeah, and I agree, Sharon, although I got to tell you that the Germans relaxing construction standards, that worries me. But that's a whole nother separate panel to discuss that. But Zach, one of the things I see is I think this is really going to have an impact on how projects are financed, particularly in the private sector, because this is going to create a lot of risk for privately financed projects, particularly if they look upon force majeure, as I think most of the contractors are going to try and push force majeure to be both a time and a compensation event. And they're going to look at what's the next COVID-19? How does that impact my project? How does it impact my project cost? What's my ROI look like for this investment at the end of the day? So I think you're going to get a much, not a much more rigorous, but you're going to see some different focuses and project financing agreements and things along those lines arising because of this, because I think this will have an impact on those agreements as well.
And so let me, we do have a couple questions. Yvonne raised two questions, definitely said German developments definitely deserve a separate webinar. So that'll be the next task for ICDRY and I.
I will contact my German colleagues to see what we can do.
And then separately to Yvonne, yes, this will be recording, and the ICDR and I will post this on their website. shortly after. I think I'll leave that to Rafa to kind of sort out, but it will be recorded and posted. The other substantive question, and this is one that I raised with Sharon when we first spoke a couple of weeks ago, was about the usefulness of dispute boards. And so, I know we only have a very short amount of time, but would you mind just responding to that one really quickly?
No, I think the question is, how do you see the impact of COVID on the role and effectiveness of dispute boards? And I absolutely think that dispute boards have a role to play when we consider that dispute boards are already involved in the project. They generally do regular site visits. They know the issues on a project. So whether they're asked for, depending on their contractual mandate, an advisory opinion or a determination that could be interim binding or binding, depending on how the dispute board is set up, that could really help keep the funds flowing, as Steve said. If a dispute board is able to give guidance to the parties on how these kinds of difficult to quantify costs are going to be addressed based on their either recommendation or interim binding or binding decision.
And Sharon, just to add to that, I think dispute boards are great. Unfortunately, they generally only work on larger scale projects because the cost and other impacts there. Zach, one of the things that I've played around with, and I think this goes back to the whole conversation we had about cooperation, is that in a lot of these instances, the owner is going to see a cost of this, and the contractor is going to see a cost here. So there's going to be a gap. And what we tend to usually happen in these instances is that we fight about the whole thing. And I think one of the ways that we can help the whole industry survive is let's find a spot somewhere, and whether it's here or somewhere in the middle, if the owner thinks the contractor is entitled to at least $1 million, pay the contractor the $1 million so he can make his payroll, so he can go forward and keep operating. I think, and these are things that dispute boards or mediations can help get to in order to keep these things running, because this is not a zero-sum game at the end of the day. Contractors need owners for projects, and let's face it, owners need contractors, because if we get down to 1 or 2 contractors, your pricing goes out the roof, your projects aren't going to go. So it's a symbiotic relationship from there, and I think we need to figure out how to make that work.
I would like to add that dispute boards have certainly worked well in Latin America, and the cost, very low, and the benefits, are there, I have seen, some chart which was prepared by the government of Honduras, okay, and the cost, was extremely low, and the benefits, they were huge, really huge.
So with that, I believe we are out of time. I don't want to keep the attendees lingering for too long. So first, I guess I just want to express my gratitude to all the panelists. It's been a pleasure working with all of you and having you here, and I think it's been a wonderful discussion. Again, special thanks to the ICDR Y&I, to Rafa and to Louis for their help. And like I mentioned earlier, this has been recording, and we will post it to the ICDR website shortly. I don't know, in the next couple of days, next week or so. We've done this for past ICDR Y&I virtual panels, so hopefully this will be a resource to people in the future. And with that, I'll let everyone go, but thank you again. It's been a pleasure on my side, and have a great day. So thank you, everyone.
Thank you.